Hello, this is Michael Paris. This is video number 2 in the series that has to do with the aftermath of Brown and school desegregation. Um, we left off with the Birmingham demonstrations in the spring of 1963. A couple things about 1964. Kennedy is assassinated, Lyndon Johnson takes over. It is an election year, 1964. It's marked by continued polarization and violence with respect to the Southern Civil Rights Movement. There's something in Mississippi in 1964 called Freedom Summer, which involved college kids or young people, white and black, leaving the North and other regions of the country to go to the South and do civil rights work, educational projects, voting rights. 3 of these workers were murdered in Philadelphia, Mississippi in the summer. Their names were James Chaney, Andrew Goodman, and Michael Schwerner. And this was again another sort of very well publicized sort of crisis event. Lyndon Johnson is running for president from his position as president. He faces a very conservative, kind of quasi-libertarian opponent in Barry Goldwater from Arizona. And it's in July of that year that the Civil Rights Act is passed. So we're on slide 3 in my PowerPoint, and if you go to the next slide, slide 4, you see the various titles of the omnibus legislation that was the Civil Rights Act of 1964. Title 1 dealt with voting rights. It was ineffectual, had to be superseded by the Voting Rights Act of 1965, which involved basically a federal takeover of the Southern electoral machinery. Title 2, public accommodations. We talked about the civil rights cases and how Congress had to use its interstate commerce power to reach those matters, matters of hotel, restaurant discrimination. Title 4 is about school desegregation. We'll get back to that in a minute. Title 6 says if you get federal funds, if you get federal assistance, you have a non-discrimination rule. Title 7 is about employment discrimination, and Title 7 also includes a ban on discrimination based on sex as well as race. I think it's fair to say, looking at legislative history, looking at the text of the statute, that the thrust of it is toward a kind of a colorblind perspective. It always sounds in racial neutrality. It really is an embodiment in a broad range of congressional mandates across a range of areas of enacting the anti-discrimination principle at the heart of Brown. You could debate that. Some of the language isn't really clear about what is or isn't discrimination, but I think the basic thrust of it is color blindness, and that becomes problematic within a few years because of the heightened conflict in the sense that a colorblind rule, may not do what needs to be done to remedy our long history of racial subordination. The next thing on the slide is the Selma March and the Voting Rights Act, and this is again another conflict in Alabama where blacks couldn't actually vote, and there was another confrontation, another riot, a police riot during a civil rights march that led to the Voting Rights Act. 1965 is also the year that Lyndon Johnson, even though he had run as a peace candidate, said he wouldn't send American boys to do what Asian boys should be doing in Vietnam, South Vietnam, committed, massive forces to South Vietnam in a civil war. So the Vietnam War then becomes part of the picture of politics in the 60s, and it takes up more and more of Johnson's energy and time. So he has less time for social reform, racial reform, and welfare reform. Young African Americans are getting very frustrated and angry, and they're kind of many of them are turning away from the philosophy of nonviolence and talking about black power, which meant many different things to many different people. But this is the context that we're going to be talking about, and this is a long kind of wind up to this. You're reading you're really reading 4 important school desegregation cases: Green, Swan, Keyes, and Milliken. So what I'm going to do now is backtrack. I'm gonna go back in time to Brown and say what happened with school desegregation in the South and how the issues got worked out and framed and why, and what that meant for the nation, and how the law, how national law, how the court, as it defined the Constitution, came to understand the meaning of Brown and the implications of Brown for the nation when it came to segregation in the schools. Right, so we'll go back to, I'm on slide 5, and you can see that the title of that slide is School Desegregation After Brown. We have the all deliberate speed pronouncement in Brown 2. We're not sure what that means. We do know that it's going to be school boards in the first instance, and then local federal district courts that are populated by Southerners that are going to be overseeing this process. So, you know, there are reasons not to be optimistic about too much change too fast. What is all deliberate speed? But no, there's no change. The South develops several ways to, the white South develops several ways to evade Brown. And I'm just going to talk about a few of these and the problem. You know, why is it that schools were not desegregated in the South for many, many years after Brown? Well, you cannot assign students to schools based on race. The states developed, and these were just blatant evasions, right? They developed what were called pupil placement laws, which said, well, we're not assigning the students to schools based on race. We're assigning them based on their intellectual ability or their moral character. And lo and behold, you know, those assignments were kept the schools separate, right? Who was fit to go to school with whom? When those methods were challenged and struck down slowly over time, another more prominent and later method was known as the freedom of choice plan. So what we'll do, and this was done especially in sort of rural districts where there wasn't that much housing segregation, or wasn't sharp housing segregation, we'll let everybody choose which school to go to. And what would inevitably happen was a few brave blacks would choose to go to the formerly white schools, and no whites would choose to go to the formerly black schools, and you would still end up with mostly segregation, with a few token blacks in the white schools, perhaps, right? Virginia had a particularly unique way of handling it. It ordered that any school ordered to desegregate would have to close its doors. One district, Prince Edward County, was one of the districts challenged in the Brown decision itself, was one of the cases, had its schools closed for 4 years, and the white students were given vouchers to pay tuition at private schools, and the black students were left without educational opportunities, right? So just school closing laws. All of these methods were transparently evasive. They were challenged in federal court. At the bottom of slide 5, I have a phrase called litigation and whack-a-mole. You know, the whack-a-mole game where you hit a mole, but another one pops up, and you keep hitting, and they keep popping up. You can't litigate against every school district, and even if you beat a school district in court, they just come up with some other race-neutral method that is intended to keep things the way they are. So that's one reason that change was so slow to come. Another reason that change was slow to come is because the court was under a lot of pressure. It was being attacked as being sympathetic to communists because it had made some decisions protective of communists and their sympathizers in the late 50s. It was being attacked for Brown. Its legitimacy was under attack, so the justices might have felt. So they were reluctant to say anything more clearly or sharply. I mean, they intervened on 2 occasions between 1954 and 1964. And those occasions were both occasions of clear, outright, violent defiance of federal authority by state authority. So there was the Little Rock case that I told you about in the last video, where Eisenhower had to bring in force and had to enforce the federal court orders. And then in 1964, the court finally ruled in the Prince Edward County case that you had to reopen the schools. You couldn't close the schools to avoid some measure of desegregation. But as a result of all this, and it's the bottom of slide 6, in 1964, about only 1% of all black students in the South attended schools with any whites. So really nothing happened for 10 years after Brown. Now, we go on to the next slide, which we're starting to get from description to, some discussion of, and some analysis, some discussion of why. So the slide is, why did change come to the South? Scholars point to two main reasons, and they're on the slide there. It's slide number 7. We have Title IV of the Civil Rights Act that says no segregation in the schools. Right? So that becomes federal law. If it's federal law, then the federal government is charged with enforcing it. We now have U.S. attorneys general and U.S. attorneys throughout the country interested in enforcement, charged with enforcement. So they are given authority. The Attorney General now has authority to investigate complaints and pursue compliance. So now we have the resources of the federal government joining whatever meager resources the civil rights forces have in enforcement activity and litigation, right? Title VI of the Civil Rights Act says, if you discriminate, you will lose your federal money, right? So local districts do get federal funds. In 1965, and this is the second prong of it, in 1965, Congress passes an education act called the Elementary and Secondary Education Act of 1965, and that puts $1 billion more into federal aid to education for each of the next 2 years. So that's a lot more money that's at stake with a threatened funding cutoff. So there starts to be enforcement pressure both from the Department of Education and from the Attorney Generals based on the Civil Rights Act. The next slide is slide 8, and that is Title IV of the Act. And here, we have this kind of puzzle about what desegregation means and color blindness. And I've put up Section 402 of the Act, and it reads, desegregation means the assignment of students to public schools and within such schools without regard to race, color, religion, or national origin. But desegregation shall not mean the assignment of students to public schools in order to overcome racial imbalance. It's not a right to integration. You are not ordered by this law to integrate the schools. Desegregation doesn't mean that you have to overcome racial imbalance. Now, you don't have to do that. Could you do that if you wanted to? If you had racially isolated schools, and you could say that the cause was mainly housing segregation. Never mind for a minute how much the government has to do with that housing segregation over time. But could you voluntarily pursue racial integration? And I think from the 60s through the 80s, through the end of the 80s, really people thought, yes, you could if you wanted to democratically pursue it. But you see here this concern with the cause of segregation and the nature of the wrong. The Act seems to say that there isn't any constitutional problem or legal problem with the fact of segregation. The problem is if the government intentionally mandated or caused it somehow through intentional action, right? So that's an important thing to keep in mind. The next slide specifies Title VI and again talks about the federal bureaucracy that can enforce Title VI. This is how change started to come to the South, through federal dollars, federal litigation, and federal pressure, combined with the civil rights movement. And there is an agency within the Department of Education. It's called the Office of Civil Rights, OCR. And it's located within the Department of Education, and it's going to be involved in developing the definition of what should happen after Brown. And it issues these guidelines, and they change. In 1965 and 1966, we get these guidelines, but the important point for our purposes, is the 1966 guidelines end up with numerical goals. Like we're going to measure how you're doing by the numbers, by how much actual desegregation there is in districts that have intentionally mandated racial segregation. Right? And then a lower federal court opinion called United States v. Jefferson County in about 30 school districts from Mississippi endorsed those guidelines as the constitutional standard. That what it meant to comply with Brown now meant to produce some measure of actual desegregation, right? And note, all the while, the U.S. Supreme Court has lots of opportunities to weigh in and speak on this issue, and it's not doing that. So this is 15 minutes, and this brings us to where I wanted to be by way of context with Green. So I think I will break up the next two videos. It will be Green and Swan, which are southern cases, and then Keyes and Milliken, which are northern cases, and we'll have occasion to talk about what the arguments are and what the principles are there. Okay, end of video 2.